comments, which is a sign of intelligence. If I may point out one thing about the previous case on Sarah Eakes and this case have one thing in common. I inherited both of them from former lawyer Jim Todd, now Judge Todd, after being elected to the General Sessions Court of Davidson County, Tennessee. I noticed that in one of the briefs, there's a reference that Mr. Todd or that Mr. Jones had appointed counsel. Oh, and I apologize. I am Pat McNally of Nashville Bar, Tennessee Bar, and if I may, I'd like to reserve 5 minutes for rebuttal, which I may need in this one. Mr. Jones filed a pro se petition for post-conviction relief, and he was appointed counsel, and eventually he was appointed a second counsel, and then Mr. Todd was eventually retained, and he took him all the way through where Mr. Jones then filed a pro se notice of appeal. Counsel was again appointed, and then the family came up with funds to hire me to pursue the appeal on behalf of Mr. Jones. This record here before this court clearly shows deficient performances by trial counsel on behalf of Mr. Jones. The real question comes down to, did it make a difference? The harmless error standard. And that's always tough on the post-conviction cases. The brief raises 5 different claims of ineffective assistance of counsel. I'm going to try to focus on 3 of them if time permits me here today, starting with the failure to impeach the star witness for the state, then the failure to request a curative instruction on the Bruton violation, and finally the failure to do any pretrial motion practice about the single photograph in this particular case. The star witness in this case was Iris Pinson, and frankly, to summarize her testimony, she said that Mr. Jones and his co-defendants came by her home. The co-defendants' names are Toll Morales and Conte Valentino. That they came by her home and talked about committing a robbery, and that Mr. Jones even said that he was going to get drugs and money from the robbery. That they then came back by her home. 2 of them were covered with blood. Mr. Jones had a small amount of blood on his hand, and she testified that that Mr. Jones then collected up the bloody shirts and told her to keep her mouth shut, to act like nothing had happened. And she further testified that eventually, some weeks later, Mr. Jones drove Mr. Toll Morales to Florida, helping him escape apprehension. Interesting, she also made the statement that Mr. Conte Valentino reported that the victim was stabbed before being shot, though she went on to testify she couldn't remember if it was Mr. Valentino who did the stabbing or Mr. Jones who did the stabbing, which goes to the Bruton issue, which is part of this, in the brief.
So,
yes, sir.
Let me ask you this. In reading the briefs, obviously, I don't know how it played out at trial. We haven't read, all that. But so one of the things, and you just alluded to it in your kind of opening remarks there, was she talked about how they all came back with blood on them. Mm-hmm. And as I read the state's brief, counsel, at least at some point, whether it was in closing or maybe even during questioning her or a police officer or somebody, inquired about where all these bloody clothes are. Is that correct? Is that correct that he at least asked that question somewhere? Maybe it was in closing, but at some point.
He did ask of the police officer, if there was all this bloody clothing, how come there's no blood inside the Yukon that you eventually seized?
Okay. So even though, I guess I'm getting to the prejudice part here. Mm-hmm. So yes, would it have been maybe a better strategy to actually ask the star witness about all the, why isn't there blood all over your apartment? What did you do with the bloody clothes? Those kinds of things. If counsel at least points out somewhere in the trial that despite this claim that everybody was covered with blood, the police found no blood, how do you get past the prejudice then? Because he's raised the point. They claim blood, there's no blood.
I understand. And that is not necessarily where I'm saying trial counsel was deficient. Where I'm saying trial counsel was completely deficient was the failure to impeach Ms. Pinson with her prior inconsistent statements. Yes, he raised the point that there was no blood found inside the Yukon. I don't believe he ever raised any issues about no blood found within the house. Okay. But he did raise that issue. But what I'm going to is, as was described in, let me get to my notes. Well, his cross-examination has been described as a great engine for search of truth. In the book, The Lost Art of Cross-Examination, author Earl talked about the hallmark of cross-examination is the act of impeachment by inconsistent statements. Now, I think what you've got there is her testimony is inconsistent with the physical evidence. That's one form of impeachment. But the best form of impeachment is prior inconsistent statements. As any trial judge and any trial lawyer knows, and every prosecutor worries about, is prior inconsistent statements. And here, we have abundance of them. For instance, in her interview the second interview to the police, contrary to her trial testimony, she said she could not recall if Mr. Conte Valentino had said that R.O. had stabbed the victim. But she told it, well, I'm sorry, that was her trial testimony. To the police, to law enforcement, she said that R.O., which is also the name she knows Mr. Jones by, she doesn't know Rodney Earl Jones, she just knows R.O. She says that R.O., that someone told her he did do the stabbing. Also, she didn't say, she said that Jones, she says that Jones never said anything about the robbery in her statement to law enforcement, in contrast to her testimony that he had discussed the robbery beforehand and that he discussed it afterhand and that he told her to keep her mouth shut. In fact, she says she says she never really even saw him until a few days later, and that he actually arrived later to pick up his co-defendants.
So, I don't disagree with you that in front of a jury, being able to impeach a witness, hold the piece of paper up, and didn't you say that? I mean, it's great. And
I don't mean to interrupt, or to call, or to ask that, and then have the officer get on the stand and say, she did say that. Right.
I mean, the theatrics and the impact on the jury is fantastic. I'm not disagreeing with you on that point. But to get to the prejudice prong, and as I understand the state's brief and how the post-conviction court kind of analyzed this, was the post-conviction court looked at the big picture of the whole trial. And while he may not have, while counsel may not have pinned Ms. Pinson down, so to speak, on numerous points while she was testifying about contradictions she made, he did make those points at some point during the trial, whether it was with another witness, whether it was during closing. So the things you're concerned about were brought out. They may not have been brought out the way you would have liked them to be brought out, but they were brought out. If that's the case, and that's how the trial court analyzed it, you know, the standard is not, you know, how I or you would have tried the case. It's how a reasonable attorney would have tried the case. Is that not reasonable for at least the attorney? They may not do it the way you want it done or I want it done, but if they put it out there in front of the jury, isn't that reasonable?
Absolutely not in this case.
Okay.
There is absolutely no reason not to impeach Ms. Pinson, the star witness for the state, with these inconsistent statements where, let's not forget, the very first time she's interviewed, when as she described it, the police raided her home, she said she knew nothing. And in fact, the co-defendant, Tolis Morales, or Conte Valentino, was in California, is what she told them. We got that as our first story, okay? This is a ever-shifting stories by her, and you don't let that go if you're a good trial attorney, and that is far below the reasonable standard expected of an attorney. May I also add, though, trial counsel didn't even ask her about the statements that she made to the private investigator for one of the co-defendants, Patrick Wells. She said in that statement, which is after the police statement, she says only Tol Morales visited her apartment on the day in question to tell her about the planned robbery. She made no mention of Mr. Jones ever visiting her apartment or discussing anything about robbing any of the victims. She said, again, she repeated, though, that Jones had picked up Conte Valentino and Tolis Morales afterwards, after they had come back to her place and afterwards. And she stated that she did not speak with Mr. Jones until a couple days later. And finally, Jones was not in the party that drove Tol Morales down to Florida, which is all contrary to what her trial testimony was. Now, let me point out, the cross-examination has no reference whatsoever to any of the things I just referred to in the statement to law enforcement or into the statement to private investigator Patrick Wells. Not one iota mention of it. And in his closing argument, counsel doesn't get into those statements because he isn't prepared. He's not aware of them. In fact, he admitted that during the post-conviction hearing. And I understand why he probably didn't cross-examine her about the fact that her very first statement is, I don't know anything about this. And in fact, who you're looking for is in California when she lied about that. I assume it's a lie. Because that was sprung out by Ms. Pinson during her direct examination. And not provided by the state, which goes to our Brady issue that's also part of in the brief there. But if I could, Your Honor, I'd like to point out that the trial court actually, and there's two judges on this case. There was Judge Wyatt, who tried the case, who then retired, and the successor judge who took over, who's a very experienced assistant district attorney. She had years of practice at the district attorney's office and tried many cases. And I know from, I guess this is just personal experience, but I know she's a very, very competent attorney, and she's a good judge. And she pointed out, she said that she made a finding he, meaning trial counsel, could have employed a better strategy in questioning Mr. Pinson's credibility. That's in volume 2, page 198. She then, this is where, going to your prejudice, she then says, the trial court says, going to the prejudice factor, that there was no way for the court to conclude that the jury would have found Ms. Pinson not credible if counsel had cross-examined her with the prior inconsistent statements that she had made. That's in volume 2, again, page 198. But the court did not go on to explain why she didn't think that it would have impeached Ms. Pinson's testimony. I don't think anybody here would deny that it is effective representation to point out prior inconsistent statements of a witness. Granted, I would like to do it during the witness's testimony, and in fact, you kind of have to. Don't the rules of evidence require me to confront the witness with the prior inconsistent statement before I can call the detective to say, hey, detective, didn't she tell you something different? Don't I have to confront her with the statements that she made to Patrick Wells and say, hey, didn't you tell Patrick Wells that Mr. Jones wasn't even around? He didn't show up till later.
Mr. McNally,
yes, sir.
Did the district attorney in this case try to sort of derail the cross-examination by putting some of this information in direct?
He did try, yes, the district attorney did a good job of what I call bring out your garbage, and he did bring it out during some of the direct, but trial counsel failed to pick up the ball and go with it.
Did the witness admit that the witness was lying on the first and second maybe statement she gave to the police?
Not clearly. It was really the very first one that she came out and blatantly said, yeah, I lied. I lied when I said I didn't know anything about it.
So the jury had enough there if they had decided to find her not credible from the direct examination?
I would disagree. I think it wasn't developed well. No assistant district attorney does a good job of showing that their witness is not credible. They soft pedal it.
Yes.
And this trial attorney was not prepared. There's evidence in the record that he wasn't able to play the previous statement by Ms. Pinson to law enforcement. I'm not saying I can't say that the record shows that he never listened to it, but when he went to play it for Mr. Jones at the jail, there was a computer foul up, and he wasn't able to share it with Mr. Jones. I just emphasize to the court the importance that legal authorities and people who teach about cross-examination emphasize to lawyers about prior inconsistent statements. We really look for them. We dig for them. And Rule 613 provides that you can impeach a witness with prior inconsistent statements. The trial court's decision, or the trial court's ruling that she just couldn't tell if this would have made or if it would have impeached her credibility, I think is error.
Well, that's kind of my next question, though. So in order to establish the prejudice prong, let's just say he's deficient. Let's just all agree he's deficient for the purpose of this question. In order to establish the prejudice prong, you have to establish that, but for his failure to cross-examine her properly, the outcome would have been different at trial. I read, maybe I'm wrong, I read the quote that you just read to me as the trial court saying it wouldn't have made a difference. There's enough proof without her contradictory testimony that he's guilty of this crime.
If I may, with the 20 seconds I have left, let's go to cumulative error. All right, let's say we chip away at her credibility with this cross-examination, and maybe I don't on it alone have harmful error, okay? But look at this single photograph identification that's in the brief there. He never even filed a pretrial motion to challenge what this court and the Supreme Court has repeatedly said, very suggestive. Didn't even get into inquiries about whether it could come in because it's reliable. He didn't even challenge that. And remember, she only knew him as Roe. And in fact, in some of her statements, she said, I've never met him, never talked to him. Now, let's say we challenge that photographic identification and it gets excluded. So now we have her not able to identify anybody. Maybe they're allowed to identify in court or not. Then we've chipped away at this right here. And then you look at the failure to do the curative instruction for what was clearly a brutal violation, when the witness was allowed to say that another witness, a co-defendant, said that either he or Mr. Jones stabbed the victim, which we all know there was no stabbing. Now, this court, on direct appeal, found that was waived, but they went ahead and addressed it and found that the brutal violation was harmless given all the evidence there. What I'm saying is, once you start chipping away at all this evidence, you get to a good cumulative argument, because what was not done here is trial counsel waived asking for a curative instruction on the brutal violation. Didn't ask for immediate admonition to the jury and didn't ask for a jury instruction. And this court here found that was waived and not subject to plain error. That was clearly ineffective assistance of counsel, deficient performance. And I think when you combine all these together, you get to the harmful effect, because chipping away, you begin to see that you can discredit Ms. Penson's testimony and distance her from Mr. Jones. I do accept that it's always a tough challenge to show the harmful effect of it when you looked at the overall trial. But I think the cumulative error here is what shows that.
Okay.
Thank you, Your Honor.
Morning, General.
Morning, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgment of the post-conviction court because trial counsel did not provide the ineffective assistance of counsel. Turning first to the issue of his cross-examination of Ms. Penson, trial counsel testified that he had reviewed her statements to both detectives and to the private investigator. So he was aware of those, and he also had a specific strategy for cross-examining her. He said he wanted to call her credibility into question and try and impeach some of her testimony, and that's what he did. He brought up the issue of the Suburban or the Yukon not having much blood in it, while she claimed that at least 2 of the co-defendants were covered in blood. He also brought up sort of her history with drugs and narcotics and tried to tie her into potentially the robbery with that. The issue here is that the trial counsel simply did not employ the line of cross-examination that the petitioner, with the benefit of hindsight, now wishes he had. But that's not how we measure whether counsel's performance was deficient.
Is that really, though, the benefit of hindsight? I mean, she gave 3 different statements, basically, none of which match. And he did nothing to point that out to the jury. I mean, it's hindsight, yes, in the sense that it happened. But I mean, like, that doesn't take a whole lot of foresight on counsel's part to figure out, hey, I've got 3 contradictory statements, and I don't point out any of those to the jury?
No, Your Honor, he didn't, but I think there's enough testimony here to show that this was, in fact, a strategic choice, that he had the statements available, he could have used them, which indicates that he made a choice to pursue other lines of cross-examination. And as the U.S. Supreme Court has said, simply because a tactic doesn't work out the way that counsel and the petitioner hoped it would, that does not mean that counsel's performance was deficient.
What was his strategy then? If it's a strategic choice, I've got other things, but I've also got these 3 inconsistent statements. So what strategy is there to leave out that part?
I think it was to go after more of the issue with the blood, that was sort of, we had documented proof that she makes a statement that the Yukon, or that the 2 co-defendants were covered in blood, but we've got the evidence saying that there's really not that much blood in the Yukon. I think that was counsel's strategy. And this sort of goes to the prejudice analysis, but we don't have Ms. Pinson's testimony at the post-conviction hearing. We don't know how she would have responded if she was asked questions about these alleged inconsistent statements. It could have been a thing where she might have given an answer that could have hurt the defense more than it would have helped it, which could go to trial counsel's strategy. It was also something, though, that the petitioner did not ask him about at the post-conviction hearing.
He didn't volunteer that I stayed away from those inconsistent statements because I was afraid there was something there that might hurt my client, though. Did he?
He did not, Your Honor. He spoke just largely, it was a more general description of his strategy in that he wanted to impeach Ms. Pinson and call her credibility into question. And that's what his cross-examination shows that he at least attempted to do. And I think the post-conviction court got it exactly right when it said he probably could have chosen a different tact in cross-examining Ms. Pinson, but there's enough here to show that he still made a reasonable strategic decision.
So the defense counsel made a decision not to put on proof that would show the witness was a liar, and instead relied on her criminal drug use and no blood in the Yukon to impeach her credibility.
Yes, Your Honor.
Proving that she was lying would be pretty good evidence to impeach credibility to me.
It would, and there was the thing that was brought out that Ms. Pinson admitted she did initially lie to police when she said that Mr. Tully Morales was in California, which was, so the jury was aware she had lied and that her credibility was in question. But even if we get to the prejudice prong, the petitioner simply cannot establish prejudice here for multiple reasons. One, again, we don't have Ms. Pinson's testimony at the post-conviction hearing, but her testimony was not the only evidence of the petitioner's guilt. You had the testimony from Mr. Joby, which heavily implicated the petitioner in the crime. He said that the petitioner told him that he was going to rob the victim, that he made this statement while with his 2 co-defendants. He called Mr. Joby on the day of the shooting and said, the robbery went bad, I think the victim might be dead. He tried to store a gun in Mr. Joby's car and asked Mr. Joby to provide him an alibi, which Mr. Joby declined to do. Excuse me. Then we have cell phone records that show the petitioner using a cell phone tower almost right in front of the victim's house, and then surveillance footage showing a car similar to the petitioner's passing a business near the victim's house shortly before and shortly after the murder. And even trial counsel admitted at the post-conviction hearing that it was problematic to have Mr. Joby, who had no connection to Ms. Pinson, provide a similar account that implicated the petitioner. So even if we do get to the prejudice prong here on this issue, the petitioner's not shown a reasonable probability that, but for counsel's failure to pursue this particular line of cross-examination, that the result of the trial would have been differently. And then I'd like to briefly touch on the other issues that have been raised here today. First, regarding the motion to suppress, there's no proof here that a motion to suppress would have been successful. To suppress an identification, you have to show that it was both unduly suggestive and that it was unreliable. And here, the petitioner fails on the reliability prong alone.
So, I mean, I know the case law is very, very clear that if you're going to raise counsel was ineffective for failing to move to suppress something, you basically have to put the suppression hearing on at the PC hearing. And your position is that did not happen. However, I think the case law is also pretty clear that a single photo lineup is extremely suggestive. So is the state's position that even though there's plenty of case law saying that a single photo lineup is problematic or can be problematic, you still got to go through the whole suppression issue like you would if it were just a bad photo spread and we're arguing, well, they all don't look the same, that, you know, he looks different than everybody else in the photo spread?
Yes, Your Honor, that would be the state's position, just because, and very much acknowledging the plenty of case law saying that single photograph lineup can be problematic. I think you would still have to put on a little bit of proof as to sort of the circumstances surrounding the lineup itself, maybe how it was created, how it was presented to the witness. But you'd also need to put on that proof to show that the lineup itself was unreliable. So that's where the need for the motion to suppress would come in. It is to both prongs, not just to the first one. And the proof that we do have shows that this identification was reliable. Both the petitioner and Ms. Pinson at different times admitted that they had known each other. They'd encountered each other before. And this court has said on multiple occasions, prior knowledge of a defendant or an ability to interact with that person well before the crime weighs heavily in favor of the reliability of the identification. So here, since the petitioner and Ms. Pinson knew each other, counsel had no basis to challenge the reliability of the identification, and the petitioner's not shown then that a motion to suppress would have been successful, and he therefore cannot show any prejudice. And then turning to the final issue, the Bruton issue, trial counsel did testify that he was noting inconsistencies in Ms. Pinson's trial testimony and was saving them in his mind to try and bring up later. He said that her testimony that Mr. Toll Morales said that the victim was stabbed was inconsistent with the medical proof. He didn't bring that up on cross-examination, admittedly, but his testimony shows that he was at least trying to keep these inconsistencies in his head to possibly bring up later on cross-examination. But the petitioner also cannot establish any prejudice in this regard because, as this court previously determined, that one statement from a co-defendant was harmless. It had almost no impact on the proof of the petitioner's guilt. In fact, it contradicted the medical proof and therefore would have actually undercut Ms. Pinson's credibility. And
how do you respond to counsel's argument, though, that, you know, the inconsistencies, well, you can't really establish prejudice, but maybe it's close. And this may not be able to establish prejudice, but it might be close. And then there's, all of a sudden, at some point in time, that adds up. So how do you respond to his cumulative error argument, I guess?
in two ways, Your Honor. First, with the same position we took in our brief, there's not been multiple instances of counsel's performance being deficient, but even let's say that there were, the proof here is simply overwhelming in that we've got nothing that would undercut Mr. Joby's testimony implicating the petitioner. We've got nothing to undercut the cell phone records, the surveillance footage, and then even the petitioner's claim of an alleged alibi defense has not been proven. There's nothing to show that he went to all these places and therefore could not have committed the crime. So even if we do have multiple instances of deficient performance, there's simply not enough here to rise to the level of Strickland prejudice based on the substantial evidence of the petitioner's guilt. And unless there are any further questions, we would ask this court to affirm the judgment of the post-conviction court. Thank you.
Thank you, General Douglas.
Post-conviction counsel did a fine job of trying to show that there would have been an alibi available. They hired private investigator Rebecca Calcook, who went to all the places that Mr. Jones testified to his alibi and said he had informed his trial counsel. In fact, trial counsel was aware of this alibi when Mr. Jones gave a proffer to the state and sat there and listened to it.
But he testified, if I read the state's brief correctly, that he didn't say that stuff during the proffer and that he never told him about an alibi.
Well, the proffer is in the record, and he actually, I thought he said he did not remember whether he had done it or not. The proffer is in the record. But in looking at that, Investigator Kalchuk ran into hurdles because of so much time going by. She went first to, she tried to locate Miss Pinson and couldn't find her anywhere. Then she went to the place where Mr. Jones said he had dropped his wife off. And yes, they had surveillance cameras and everything, but it was almost all these places where there were surveillance cameras. At the Roadway Inn, where he said he smoked marijuana with Patry, and unfortunately that witness passed away. At the cell phone stores that he went to, they had not retained their records over so much time. Berry Pawn Shop remembered Mr. Jones coming in and doing business there, but they couldn't pinpoint a date because their records had been destroyed in 2017. But there is one record that they were able to find, the Nissan dealership. And that is in the record here. It's exhibit number 7, and it does show on that very day that he was at the Nissan shop, or Nissan dealership, picking up his vehicle, which would contradict Miss Pinson saying that he was over at her house, or would contradict Mr. Job saying that he was riding around with him between 5 and 6 o'clock with the gun that mysteriously, for the first time, is now put in Mr. Jones's hands. No one else has ever said anything about Mr. Jones having the alleged firearm that killed the victim until Mr. Job. And by the way, Mr. Job was very impeachable. He was looking at a long sentence in federal court, and I think the co-defendants' counsels did a pretty nice job of cross-examining him and impeaching his testimony. And I'll tell you one thing. If you get me down to one witness pointing the finger at my client at trial, I got a lot better chance of doing something with the case than I do when I've got 2 independent people pointing the finger at the client. Now, as far as the Bruton issue, trial counsel's testimony at the post-conviction hearing was that he didn't recall noticing any Bruton violation. And that's credible, because he didn't ask for an immediate admission, he didn't ask for a mistrial, and he didn't ask for a curative instruction later, which is why this court found on direct appeal that it was waived, because he never asked for a written specific jury instruction on that matter. He missed the Bruton issue, despite the fact that it had been discussed pre-trial at length by the co-defendant who filed the motion for severance, even though Mr. Jones wanted his counsel to file a motion for severance, even though if trial counsel had listened to her statement given to the police, he would know that she was saying that Mr. Jones was reported to have stabbed the victim. All this was heard pre-trial, and the state even said, "Look, we'll scrutinize the record. We'll advise our witnesses. We'll tell them what the boundary is. And if they cross that boundary," they actually said, if they cross that boundary, these defendants may be entitled to a mistrial. And that was part of that bargain for exchange pretrial as to why there was no severance of the cases. The boundary got crossed. And yet, trial counsel didn't stand up and say, "Whoa, wait a second. I get my mistrial now, right?" And even if you don't get a mistrial, they didn't ask for a curative an admonition right then and there, or curative instruction, because as he said at the post-conviction, "I didn't know it. I didn't spot it. I didn't see it." Trial counsel's whole strategy in this case was to challenge the credibility of Ms. Pinson, and he missed the pretrial opportunity to challenge her identification of Mr. Jones. Clearly, it was suggestive. A single photograph identification gets us past the first hurdle of being suggestive by the case law. That's when trial counsel needs to step up, file the motion, and then have a hearing on whether it's reliable or not. Now, there was not a suppression hearing done in front of the post-conviction court. But you look at this. Ms. Pinson only knows him as R.O., Roe. Ms. Pinson, in some statements, says she's never even talked to him, really. Not even really met him. She's not familiar with him. And we know the circumstances of which there was a photograph identification because it's in the record during the hearing or during the interview that the police were doing. It's shown to her under those circumstances when she's being questioned about it. Is this one of them? You know.
I know your time's run, but
Yes.
let me ask you one question, if you
Yes,
don't
sir.
mind. Kind of like your first case. In order to make a finding in a suppression, there has to be findings by the trial court, which is why the case law is very clear. If you're going to argue that trial counsel was ineffective for failing to file a motion to suppress, you got to put the hearing on at the PC hearing. How do we, if that didn't happen, how are we supposed to review it?
What distinguishes this case from, say, a suppression of a statement or suppression of evidence seized at a home or from a vehicle is that we get past the very first hurdle, which is that this is suggestive. It
There's
really,
still findings for the second hurdle that we
Correct.
can't make.
which is what the trial lawyer should have put before the court to do. And it is, you know, the one time that the trial counsel said that it was problematic is when he was confronted with the fact that the single line identification is problematic. That's the word, he actually used the word problematic. And I would say it is problematic since there's not the second half of the suppression hearing. But I can tell you, the door was open for a suppression hearing, and I've given you what I can from the record as to why. If I may add one other thing. Trial counsel said my whole goal in this thing was to impeach Ms. Pinson. And in closing argument, you would normally do something like this. She starts off over here, she goes here, she goes here. 3 different stories that were moved. And I like to say in closing argument, usually the truth follows a straight line, not a crooked one. And none of that was even mentioned in the closing argument. Thank you, Your Honors.
All right, thank you, Mr. McNally. Excellent briefs. We'll take it under advisement. We'll take about a 15-minute recess, please, and then we've got one more case